This time we're going to be covering the duties under the prudent investment rule. Again, something for all financial planners, because at some time in your career, or maybe many times in your career, you're going to be advising a trustee, or you might actually be the trustee, or you're advising a client on trust. And it's unfortunately too many financial planners are unaware of these responsibilities that are involved in a trust. So let's go through them. Objectives. By the end of the module, be able to list the key clauses of the prudent investment rule, describe the role of prudent investment rule in trust, discuss the flexibility of the rule, and understand the importance of good documentation. And we're talking about the new the new prudent investor rule, which is, again, I use the word prudent investment rule because that used to be called, and I sometimes forget it's now the prudent investor rule. But in either case, the rules have changed drastically in the last 30 years. So let's take a look at them. Rule 1. A trustee who invests and manages trust assets owes a duty to the beneficiaries of the trust to comply with the prudent investment rule. In other words, unless there's a clause in the trust, the trustee must invest and manage the assets per the trust rules, which are called the prudent investment rule. Second, the rule is a default rule and should be expanded, restricted, eliminated, or altered by the provisions of the trust. And finally, the trustee is not liable to a beneficiary to the extent the trustee is acting in reasonable reliance on the provisions of the trust. Now, the real problem that ends up there is what is reasonable reliance on the provisions of the trust. And there have been lawsuits, and I think the best way to get out of that for trustees is to document everything. Documentation is probably the number one thing that a trustee needs to do, and the more detailed the documentation, the better. Section 2 calls it the standard of care, portfolio strategy, and risk return objectives. A trustee shall invest and manage trust assets as a prudent investor would by considering the purpose, the term, the distribution requirements, etc. of the trust. And again, if the trust is vague, you have to get it defined. A trustee should never go ahead and guesstimate or make assumptions as to what the purpose, the terms, the distribution requirements are. Even though a lawyer may have prepared the trust, I would always have a professional trust organization look at it. And that could be a trust department of a bank or a trust company, and make sure that they find it reasonable. The attorneys are worried about the legal application, where the trustee must not only think of the legal, but the practical ramifications of what's going on. You must recognize reasonable skill, care, and caution, which is basic to the very rule of trust that go back many years. And finally, investment and management decisions are to be in context of the trust portfolio as a whole, as part of the overall investment strategy, having risk and return objectives reasonably suited to the trust. Therefore, the trust policy should call out what the risk is and the return objectives. And we should also be very careful that we look at the picture of the portfolio at the whole, not individual stocks and bonds and other investments in the portfolio. Section 2 continued. Trustee must consider the following as relevant to trust or beneficiaries: the general economic conditions, possible effects of inflation or deflation, expected tax consideration of decisions and strategies, role of each investment within the overall trust portfolio, expected total return from income and appreciation of capital, other resources the beneficiaries need for liquidity, regular income, preservation, appreciation of capital, and finally, assets, special value or relationship any to the purpose of the trust or beneficiaries. And may I again repeat that documentation is key for all of these, and you're expected to keep this up with reports to the beneficiaries. So it's a matter of this really being a checklist. And when people talk about the prudent investment rule and with trust, this shows you how difficult it is, very time consuming. A trustee shall also make a reasonable effort to verify facts relevant to the investment and management of trust assets. Trustee may invest in any kind of property or type of investments consistent with the standards of the Prudent Investment Rule. Trustee with special skills or expertise, or as named as trustee in reliance upon the trustee's representation, has a duty to use these special skills or expertise. And again, this is a latter point is when you were picked because of special skills or expertise, and or representations the trustee makes. And the trustees should be very careful in this area. Here in California, we are one of the many states who use professional fiduciary criteria licensed by the state, which makes the fiduciary think about that quite strongly. But those states who don't have the training for the trustees, or in cases where a relative is acting as trustee, many times are not following these. Again, we can go back to if it's not covered, if it's inconsistent with the trust terms of state law, then you don't have to do these. And many times the trust terms are such that they don't require some of these skills, and do encourage the use of experts. Section 3 of the rule, trustee shall diversify the investments of trust unless the trustee reasonably determines, because of special circumstances, the purpose of the trust are better served without diversifying. One I can think of, for example, is it's an apartment house that's been in the family for 50 years, and the only asset in the trust is the apartment house, and it's obvious the trustee and really the beneficiaries do not want to change that asset. They want to use the apartment house as the one assets in the trust. That would be a good example. Another one would be if the company parents who would set up the trust put the stock of their private company into it, and the private company was protection of the company from being sold to third parties was why it was put in a trust. That would be another reason. And there's more details we'll cover in Module 3 on diversification. Section 4, duties at inception of trusteeship. Within a reasonable time accepting a trusteeship or receiving trust assets, the trustee shall review the trust assets. That should be obvious. And implement decisions concerning the retention and disposition of assets, which is probably not as obvious, especially if they've inherited the trust from either the executor of the will, or if it's a lifetime intervivals trust, maybe the grantor, in order to provide the trust portfolio into compliance with the purposes, terms, distribution requirements, and other circumstances of the trust, and with the requirements of prudent investment rule. So again, whether the rule is in the trust or not, I've seen trusts that exclude the prudent investment rule because, again, of complexity. Section 5, loyalty. Trustees shall invest and manage the trust assets solely on the basis of the interest of the beneficiaries. Applies not only to the self-interest of the trust, but also to the interest of any third party. It's improper to sell trust property to a third party for purpose of benefiting the third party rather than the trust. It also brings up self-interest of the trustee, which might mean getting a commission. Impartiality. If the trust has two or more beneficiaries, the trustee shall act impartially in investing and managing the trust assets during taking into account any different interests of the beneficiaries. 7, investment costs. In investing and managing trust assets, trustee may only incur costs that are appropriate and reasonable in relation to the assets, purpose of the trust, and skills of the trustee. Again, this is another area I've seen trust advisors get in trouble with, as well as trustees. You must document the cost and how you came up with it and why you spent that particular cost. Documentation very key here. Reviewing compliance with the rules and determined in light of the facts and circumstances existing at the time of the trustee's decision or action, and not by hindsight. And that's a good rule. 9, delegation of investment and management functions. Trustee may delegate investment and management functions that a prudent a prudent trustee of comparable skills would properly delegate under the circumstances. Trustees shall exercise reasonable care, skill, and caution. Remember, all trustees cannot get out of it. They have to comply with reasonable care, skill, and caution. And this is in selecting the agents, establishing the scope and terms of the delegation consistent with the purpose and terms of the trust, and periodically review agents' action to verify performance and compliance with the terms of the delegation. Again, that has to be well documented. If everything went perfect, I guess probably wouldn't be that important, but nothing ever seems to go perfect, and there will be little glitches, and you better have this documented if you're the trustee. And I would say that the trustee's advisor should also be very concerned about documenting this. An agent owes a duty of trust to exercise reasonable care to comply with the terms of the delegation, and the trustee who complies with the requirements above is not liable to the beneficiary or the trust for decisions or actions of the agent. The agent is subject to the courts of the state having jurisdiction. And I might note that the trustee has to prove that they've met all the requirements of the previous slide in order to not be held liable to the beneficiaries. And that, again, requires a lot of documentation. And likewise, the agent has to do the same. And the agent will be subject to courts having jurisdiction. So let's say the trustee is in California. It's an Arizona trust with the assets and beneficiaries in Arizona. They will be subject to the state of Arizona. Sections 10, 12, 13, 15, and 16 of the Prudent Investment Rule are administrative and legal in nature and not really necessary for you to know, or even for the trustee to know. Section 11, however, applies to trust existing or created after its effective date, and that's through the Prudent Investment Rule. So if you don't want it to apply, then you have to put it in the trust. As applied to the trust existing on its effective date, the rule governs only decisions or actions occurring after that date. Again, it's so important to make sure the dates are in trust. I've seen several trusts without beginning dates, they just have end dates, and of course that has a problem here. Severability. If any provision of the rule or its application, any person or circumstance is held invalid, the invalidity does not affect other provisions or application of this rule, which can be given effect without the invalid provision or application. You see those terms also in wills and many times in contracts. And therefore, based on that, the rules are severable. Summary. In this module, we learned the Prudent Investment Rules have broad guidelines that requires documentation. There's numerous responsibilities. There are investments in the trust that requires documentation. The burden of proof is really on the trustee, and therefore documentation is an absolute requirement. And the provision of the trust can override the Prudent Investment Rule, except for the duties covered in Week 2.